Wanted to get.
All right, you just made yourself a witness that's totally not credible. If you would like to change that to the Eagles, we're okay.
Do I got to change that to
The Eagles.
And the Eagles, the Devils. So really,
You can't say again.
So anyway, February rolls around, Super Bowl.
And he's from Chester, right? Is that?
Yes, he is.
Yeah, all right.
So what happens is I get a call from, the teacher, my son's got to come home from work, so I have to leave, and that's another non-pre-scheduled leave. So now, I'm not a leave abuser, but now I've got 4 strikes against me, if you will, 4 occurrences of non-pre-scheduled leave. Summertime comes, now I'm using some of the contractual rights that I have. Those are benefits of being a CO.
No, just back up though. Those four examples you gave.
Right.
These are all allowed under the collective bargaining agreement.
Oh, yeah.
You have a sick day.
It's very real world.
Okay.
Yeah.
So now what happens next?
Well, then I take my vacation. I picked it and earned it, put my name in the book. We do it various ways. Generally, that's the way it is. And then let's assume that I take some vacation and then have the opportunity to work overtime. And we work it. We have a problem working, making a little extra money. So when I work overtime and take that pre-approved leave at that time, I'm penalized because I only get paid straight time.
Okay. So in January and February of that particular year, you have the 4 non-scheduled leaves.
Yes.
Then in, let's say, August, you have a scheduled vacation day, scheduled leave day for Friday. You're going down the shore, okay.
That'll work.
But during that pay period, where you have that Friday vacation day, you work over 8 hours in a shift or you work an additional shift. Because you had 4 non-scheduled days back in January and February,
Right.
you lose out on overtime in August.
I can work it, but I get paid straight time.
Okay.
And maybe we're having you repeat yourself, but I just want to be clear on this because I understood it a little different from several hearings ago. When I first heard it, what I thought was when you took your 4th non-scheduled leave, you couldn't get overtime in that week. But are you telling me whether it's non-scheduled leave or pre-approved leave, you still don't get premium time when you work
Yes,
overtime?
it's any combined leave.
Okay.
Right.
All right.
And that's why we wanted to leave it, because we think it's good.
Okay, I didn't understand that the first time I heard it, so
So
appreciate
from-
the clarification.
So from February, let's say, in that example, from February to August, you could have no non-scheduled leave, no sick days, nothing like that, and you're still getting whacked in August.
Yes, if you use combined leave.
Okay.
So if it's not the call-off kind, it's the I scheduled it kind, and I'm still getting penalized for it.
All right.
I think that well, I guess we can clarify it in their case, but I'm not sure that that's right.
Okay, well, let's try to get it right now while we're talking about
I
it.
think that it's, you are not entitled to the overtime within the pay period that you achieved the C4. Once you get, no?
No. That's been in there for quite some time. In fact, that was something new. I've been trying to get rid of it also. But that's been there for so long, it's an accepted practice. We don't like it, but it's there. This one is any combined leave, just like it says, any combined leave.
Say that.
Tim, is it your testimony that once you reach C4 status in February, you take a vacation in July, you don't earn that time towards overtime?
I'm saying if I take a vacation in July and work overtime, I do not get overtime, I get straight time.
In that pay period?
In that pay period.
With no C4, with no CN occurrence in that pay period?
The contract says what it says.
Okay.
And the Commonwealth's not sure if that's correct or not?
Correct.
Okay, well,
We'll clarify in our
overtime, you could
presentation.
clarify that. Okay, thank you.
Just remove it, right?
Well, maybe if it's not, we can just sort of, and the prior practice is, yeah, I think all we would have to do is agree that that's not the way it should work, and I think you'd make an awful lot of people very happy.
Well, that'll be clarified, and we'll see where we're at on the issue.
I would agree, that's why I was saying, I think we had to clarify it.
Okay.
I don't know that
Okay, thank
there
you.
is the punishment.
You have more for the sergeant?
Yes. Well, not on this issue. So unless there's other questions on the non-scheduled leave, I'll move to grievance procedure.
Okay.
Good. Next is number 6A. We have proposed various changes to the grievance arbitration procedure. And I'd like to take Sergeant Walsh through each particular one. The first one proposal that we're making is what?
We'd like to set up a permanent panel of 10 arbitrators each month. Each one give them enough days so that we can get our cases heard.
So, permanent panel selected by both parties.
Mutually agreed upon by both parties. We have a substantial backlog of grievances over the years. Well, I'll tell you, right now what the contract says is we do AAA.
Okay. So the current provision says you go through AAA on each single grievance.
Yes.
All right.
But we moved along.
Okay. That's what I wanted to get to you next. Have you, what's the current practice?
The current practice says that the parties can mutually agree to amend some of that language, and we do have.
What are you doing now?
Right now, we have a panel set up.
Okay. So in this regard, you're asking the board to memorialize this recent practice of the parties into the collective bargaining agreement.
That's exactly my purpose.
Okay.
And I think one of the reasons for that is that the only two people in the world, because it's not written down anywhere, who actually talked about it were Brian and I. And we set this thing up together, picked the arbitrators, we picked the dates, and we've got nothing in writing, and I'm sure that in our executive session, Brian is going to have a document that he can even come that day and hand us.
I'll do so.
Okay. And has this been running smoothly with the panel?
I'd like to believe so.
Okay. The next proposal in regard to grievances, if we can get the next slide. In the next proposal, we're talking about discharge grievances being heard within 60 days.
This is not something we've agreed upon, and this is new. Discharge grievances, we think, should be put on the fast track. Anytime after 60 days and they haven't been heard, we believe they should be put back on the table.
Okay.
Because we just really want them heard. I think it actually limits the liability on both sides. It gives them just causes on them, and kind of hastens the whole process so that they get it done in a timely fashion.
Well, you're not saying that, for instance, if we go and the union doesn't seek to schedule a grievance, a discharge for 60 days, and you specifically say, well, we're going to hold back on doing it so we can get the guy back into a pay status, we're talking about not at the fault of the union or the grievant.
Yes, that's exactly what we're talking about.
Okay.
And I don't see that ever happening. We're not going to see that. We have contractual requirements in 15 days.
Yeah.
Sergeant, have you ever been a supervisor?
Have I ever been a supervisor?
Yes.
I'm a lead worker, so technically I'm not a supervisor.
No, I mean, in any time in your career, have you ever been a supervisor?
No.
Okay. So just imagine if you had discharged somebody you thought for just cause as a supervisor, but because an arbitrator got sick or for no reason of the union or the Commonwealth, that person is put back to work in your unit that you supervise, pending the decision of the arbitrator, which you believe the arbitrator will rule in your favor. Does that have any impact on your ability to supervise?
I don't know, I'm not a supervisor, but what I would say is that I'm not even asking him to be put back to work. He'll probably sit home for all I care, but we want the process to move along quicker.
May I ask a clarification? Would that be purely on the 10-person panel, or would you consider expedited arbitration through AAA with the first available
It would be on the
panel?
And again, this would be if he is not, if his case just has to be heard.
Right, we're
We don't, the briefs don't have to be in, the decision doesn't have to be made, he just has to have his hearing within 60
Yeah,
days.
I think Arbitrator DeTrue is familiar with that process.
Yeah, and I mean, part of this, I believe, and Brian, you can weigh in here as well. I mean, part of this, I think, is a matter of scheduling. You have a panel of 10 or whatever the number on the panel is right now, and you have dates from all of them. So it's a question of when you slot the grievance into those dates, right? I mean, if you have a discharge grievance, you can say, let's slot that before arbitrator X next month.
Correct.
So really, this gets to be a matter of scheduling between the parties.
Well, I guess my first question would be, are we then basically foregoing the grievance process? All you have to do is file a grievance, and then the case just automatically gets scheduled? There's no grievance process for the local parties, and just like what's normal? I mean,
That's not what I'm saying.
well,
So,
Is once it's
Could you
been,
explain what
once
you're saying?
arbitration's been demanded.
the proposal says 60 days of the discharge.
right. So,
I would obviously say that I think 60 days is timely enough to be through step 1 and step 2 of the current process that we have. In fact, that's the last thing of this, is that we don't want to change anything.
let me make a suggestion, Brian. I think Sean threw the job on you to kind of put together some language on the panel. If you also want to put some language together on how you would handle discharge grievances, as part of that, the board, this panel will consider it.
Well, with the way we have the panel, and if Mr. Walsh is not proposing to forego step 1 and step 2 of the grievance process, I don't know if 60 days is accurate, but it's probably close to 60 to 90 days. It would get to the
Right.
panel for arbitration.
Right, okay. All right, well, let's,
That's part of another proposal I have coming up too, that cuts down the front time. So I do think it can get done.
And again,
I guess
I
the
think- I
clarifying
think
question was, are we still following the grievance process that's outlined in the collective bargaining agreement?
right. So the question becomes 60 days from what? I know the proposal is 60 days from discharge, but, you know, if you're putting together some language on the panel and the process, share that with each other, and then eventually, if there's any disputes, the board will resolve them.
Okay.
we are certainly willing to consider a reasonable proposal
Yeah.
to fast-track these, the
Yeah.
best for both sides.
And what I'm saying is, some of this you may be able to work out without the
Exactly.
panel having to decide it.
Exactly.
So if you can do that, that's
I
good.
mean, for example, one of the benefits not only to, it's obviously a benefit to the discharged individual, but it's also a benefit to the Commonwealth. For example, when you get somebody that's reinstated and there's a 16-month back pay award, that obviously
Right.
can also be avoided. So-
I mean, even if you go through AAA, if you didn't change anything and you went through AAA, generally on the discharge cases, AAA wants the arbitrator to give a date within 2 months of the appointment. So it doesn't always work, but I mean, that's what they want. So I think everybody, both sides kind of recognize the benefit of moving fast on the discharge.
The next proposal in regard to grievances, what is that?
The next one would be to file our appeals to the two joint committees electronically, or basically by email.
Okay.
What we do now is, and I'm sure some people, if they work there at the Capitol Complex, we kind of do rings around the parking lot there, and we send somebody upstairs to drop off the paperwork, and it's like a Sharpie circle around the parking lot until they come back out.
So you're going down to OA with a big box?
Exactly.
All right. And how often is that done?
Oh, a couple times a month.
Okay. And now electronically, we're talking about through email with confirmations and things like that?
Right, we receive.
Okay.
Something modern, if you will.
All right.
Speed.
And you do between DOC and OA and PSCOA, do you do anything electronically already?
We're kind of doing that already, but we're also doing the paper.
Okay. Explain what the next proposal is.
That would be to eliminate step 2A of the process as it's written now.
Explain what a 2A grievance is, or I don't know if I'm calling it right, but,
Honestly, the best thing I can say is that the whole step would work, but we just want to incorporate that in the current step 2 practice that we have. It's for a denial of leave or a safety issue. It just doesn't really make a whole lot of sense to exclude them to something different. We have a committee working